Welcome back to Winning Isn't Easy. You ready to get started? Do I have to tell Social Security about all of my medical problems if I'm claiming Social Security benefits? Now, look, Social Security uses a 5-step sequential evaluation. They want to know if you have a severe medical condition that keeps you out of work for at least a year or could result in your death, or whether you've been out of work for a year. They want to know whether potentially you meet a listing at step 3. They want to know, based on your restrictions, can you go back to your past work? And they want to know if there's other work that you can do in the mythical, not real world national economy. All of this is based on your medical records because ultimately Social Security is making a determination in part of what your restrictions and limitations are, both from a physical, cognitive, and psychological standpoint. And then they're going to address those vocational issues. So as a matter of course, I recommend my clients to tell the Social Security Administration about all of their medical problems, regardless of whether those problems may individually be disabling or not. Now, you may not think all these conditions are important. I think more is better than less. So if you, for example, you have a heart condition and diabetes, but your diabetes is under control, you may not be thinking about disclosing to Social Security that you're a diabetic or that you've gotten treatment. I think that's a mistake because while the diabetes in and of itself may not be disabling for Social Security purposes, the combination of your heart disease could very well qualify you for your Social Security benefits. That's why I think it's better to disclose everything. Now, Social Security regulations require that you inform them and submit all known evidence that relates to whether you meet the 5-step sequential evaluation. So you have an affirmative obligation to be honest and complete when you're disclosing this kind of information. And the failure to do so can result in a claims denial, and it would be difficult potentially to overcome. So what is your attorney's obligation or representative's obligation to submit evidence? Even your Social Security attorney, even myself, I'm required to obtain and submit all the evidence, including information, medical source opinions, or medical evidence that relates to the question of whether you meet the 5-step sequential evaluation. And we all can get in big trouble if we don't do that. There is no hiding the ball. I'm going to ask, and your attorney or representative is going to ask for a complete list of your medical providers so that they can obtain your medical records. And once your attorney or representative has access to the Social Security file, they're going to cross-check what medical records are in your file as compared to what Social Security has or what you may have told your attorney. Obviously, we want to make sure that this record is ultimately complete as quickly as possible. So it takes 4 to 6 weeks sometimes to get medical records. We don't want to be on the short end of this. We want to be getting these medical records as you're getting treatment. So you can see that gathering medical evidence is the key to getting your benefits. Got it? Let's take a break.